and welcome to a newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialist. As always, I'm joined by our head of legal training, Richard Snape. Hello and welcome to Unpacking the Case, the podcast where we break down the latest cases affecting the real estate sector. Today we're looking at EE and Hutchison 3G and AP Wireless 2, a case examining whether telecoms operators were occupying sites under leases or licences and why that distinction could have significant consequences under the Landlord and Tenant Act 1954. As always, I'll be joined by Richard Snape, who'll explain what happened, why the courts reached the decision they did, and what the ruling means for landowners, telecoms operators, investors and property professionals. So, whether you're involved in telecoms infrastructure or simply enjoy a good lease versus licence argument, let's unpack the case. Hi Richard.
Hello Lizzie, and how are you?
I'm very well, thank you, on this sunny Friday morning, ready to talk about a new first-tier tribunal case from the 8th of July. The case is EE and H3G and AP Wireless 2. It's all about communications equipment, but I think we're going to dwell on the Landlord and Tenant Act 1954 elements of the arguments. And we've heard the name AP Wireless a few times. That's been a topic of a few podcasts, I think. So can you give us the background? Who are they? What's this all about?
Well, AP Wireless is a multinational body, a subsidiary of another organisation, a huge organisation, and why they feature in all these communications equipment cases is because they basically usually take on intermediate leases from the landowners and get the rental from the premises from the operators. And the reason we've had so many cases about them is basically there's complicated areas to be mentioned. We'll leave off the electronic communications code and the likes. But the Digital Economy Act of 2017 came into force on December the 28th of that year. And if you've got an agreement within the 54 Landlord and Tenant Act, prior to that date, any lease renewals will be under the 54 Act, which is more favourable in terms of rentals and the likes to the landlords, whereas if it's from that day onwards, it's much, much more favourable in terms of the rental to the leaseholders. And that's why we've had all these debates about whether the 54 Act applies, but it's much more general that, I think it's got messages under the 54 Act generally, because to come up in the 54 Act under Section 23 of the Act, you have to occupy under a lease, at least partly for business purposes, and it's got to be a lease as opposed to a license. And leases require exclusive possession for a term at a rent, and that's what quite a few of the cases we've discussed beforehand about, whether they're tenancies at will and whether they're actually leases because there's fixed maximum duration or not, as the case may be. But that's the background. That's why.
So now we're back talking to them about them again. What's the arguments on this case? What's gone on?
Well, there's 8 different sites involved. 5 of them have got sort of 54 Landlord and Tenant Act implications. The first premises was a place called Edward House in Stockport, in the middle of Stockport, which I do know. And it looks like commercial premises, but it's residential block of flats. It used to be commercial premises. It was converted. But like a lot of these premises, they have got mobile phone masts on the roof. And the agreement started off in September of 2003, although the report says 2023. I'm assuming that is wrong, but so 2003. And another of the cases is a place called Moseley Court, where Moseley is misspelt in the report, which is in Birmingham, a block of flats in Birmingham. And a third premises was Palace Bingo in Bedworth in Warwickshire, all of which had these mobile phone masts. So a couple of them rooftop masts, and they weren't cordoned off and fenced off and so on. They were cabinets, and the operators had the keys to the cabinets and locked and the likes. Palace Bingo, I think the cabinets were on the side of the building, but the mast was on the top. And they got agreements, things like they were executed as a deed. They mentioned successors having rights, provisions against assignment and subletting without consent and the likes. So the question is, in all these particular sites, are they leases or licenses? Because if it's a license, it's not within the 54 Act, and the renewal would be under the Digital Economy Act. And the tribunal decided that these things were licenses. They're sort of disaggregated. They weren't fenced off. It wasn't like a green field site, which has got railings around it and so on. And they, basically I mentioned other cases, but it's akin to something like a vending machine. And there wasn't sufficient exclusive possession for a lease, so they were held to be licenses, which rendered the rest of the arguments redundant. But they went on to say that if it was a lease and dealt with some of the other issues.
Can you tell me about those?
Well, the first one, it's a good reminder case, although it does depend a bit on its facts, or a lot on its facts, was involving Palace Bingo. Because the lease there had been entered into in July 2003, or the license, I should say, well, were it a lease. The agreement had been entered into in 2003. But in December of 2011, there was a deed of variation, which again in the law report, it describes it as a license to assign, and it clearly wasn't a license to alter the premises, basically by... Well, they seem to have lost the plans as to what was going to be altered in their entirety, but involved sort of putting a longer antenna pole up for the antenna. And if you go through a fundamental variation of a lease, then it's a brand new lease. It's a surrender and re-grant. And it's not necessarily exclusive, but adding to the premises or adding to the term is a fundamental variation. So did this deed of variation add to the demise, in which case it would have been a brand new agreement. And if you don't serve the warning notices to exclude the act and so on, it'll be within the 54 Landlord and Tenant Act. And the judge just decided that that wasn't sufficient. Just adding to the size of your antenna pole was not sufficient to affect the demise, add to the demise, in which case it would have remained, if you like, within the 54 Act if it had been a lease in the first place. That was one of the arguments, but there were others besides. Shall I tell you?
Yes, please.
There was another premises on the outskirts of Oldham in Greater Manchester called Upperwood House Farm, with one of these masts there. And it was basically, if you are going to exclude the 54 Landlord and Tenant Act and serve the warning notices, then you have to go to court. If it's pre-June of 2004, it's too late if you've already got an agreement for lease. Before the tenant commits themselves to the lease, you've got to serve the warning notices, or, say in the past, apply to the court. And in this particular case, there was a letter dated July of 2003. But basically, it was signed and the likes, but it was headed heads of terms, and listing various things, including that the lease, if it is a lease, is going to be contracted out of the 54 Landlord and Tenant Act. But the agreement itself wasn't entered into until 6 years later, in March of 2009. The question is, was the heads of terms, or the agreement headed heads of terms, binding? We did a case on this in 2023, a Court of Appeal case called Pretoria Energy and Blankley Estates. Do you remember that one?
Yeah.
It's all about an anaerobic digester and whether heads of terms was a lease or not. And amongst other things, the Court of Appeal basically decided it wasn't intended to be legally binding. It would have been better if you'd have said subject to contract, and that would clinch it. But it wasn't legally binding because the agreement was going to be, amongst other things, the actual lease was going to be excluded from the 54 Act, and it can't be excluded from the 54 Act if heads of terms have already given you your contract. And basically, I think I'm not surprised about the outcome. But the judge decided that heads of terms wasn't legally binding, and so that particular argument failed as well. It could have been contracted out were it a lease. And there was one last argument as well. Can you believe that?
Yes, what was it?
There's another property, Cosmopolitan Hotel in Hartlepool. If you're going to contract out of the 54 Act, it's got to be for a term of years certain. And there was an infamous case back in late 2008 called Newham London Borough Council and Thomas van Staden, where the Court of Appeal said that if a lease is stated to be, for a fixed term and thereafter thereafter it holding over, it continues, then it's not a fixed term tenancy. And if that's the case, it can't be contracted out. Very controversial case, but we're sort of still living with the repercussions of that. If it's with a certain term, and then including any holding over period. And in this particular case, there was conditions before the lease would be entered into, like, it was conditional on getting planning permission, any listed building consents that are required, and conservation areas, planning issues as well, and also health and safety and environmental reports. So does the agreement being entered into conditional on those things being satisfied, does that sort of give rise to not being a fixed term tenancy? And the courts and tribunals have got themselves into all kinds of mess and deciding the fixed term of a tenancy. But they quoted a couple of cases, Brilliant and Michaels from 1945, and a case called Swift and MacBean in 1942, which basically said if before the actual lease is entered into, or before it becomes an issue, the conditions have been satisfied, it's still a fixed term tenancy. Swift and MacBean was basically entering into an agreement that you'd take on the lease within a year of war being declared, Second World War in this particular case, and that was held to be legitimate as long as when the lease is entered into, the war has been declared. Brilliant and Michaels was, starting the new lease would start the actual lease on the termination of an old lease of the premises. So that failed as well, and that's it. That's yet another, no doubt we'll be having another AP Wireless case or two as time goes on.
Well, thank you very much. It's only a first-tier tribunal case, but interesting nonetheless.
It's a useful case in terms of, although some things depend very much on the facts, it's a reminder of the lease license distinction. It's a reminder of that adding to the demise and adding to the term can give rise to a brand new lease, a surrender and re-grant. So it's useful in those circumstances. It brings a lot of issues in, actually.
Well, thank you very much, Richard.
Well, my pleasure as usual, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.